ancestral or, and therefore the issue arose. And therefore the issue arose in respect of such relationship between father and such illegitimate child or children. Because of such illegitimacy, such child was entitled to inherit separate property only. What is the Parliament's intention? Had Parliament intended that only separate property shall be available for conferring rights on such illegitimate child, Parliament should have easily stated like that. And therefore, there was consensus, or there was opinion that there shall be liberal interpretation rule applied. And came the case before the Supreme Court in the year 2010. And in the year 2010, there was a case before the Supreme Court of India, wherein in similar case, child born out of void or voidable marriage claiming ancestral property rights of father. And when earlier judgments were delivered by two judges in Jinia Kevatin as well as in Bharat Mata's case, similarly, now case was referred to two judges of the Honorable Supreme Court. And these two judges reached a different conclusion. Two judges, they reached the different conclusion, and they said this amendment is beneficial legislation. And there is no description of property. The word property is susceptible, is capable, and there are possibility of two meanings. What two meanings? Either it could be separate property or it could be ancestral property. Issue is therefore which version is correct, which is to be understood. And now in that case of the year 2010, in that case, the Supreme Court applied the principle of beneficial interpretation rule. And when applying the beneficial interpretation rule, the Supreme Court held that, the Supreme Court opined that this is equally applicable in respect of ancestral property also. And therefore, there were inconsistent views. There were different views recorded by two judges on one side and two judges on another side. In case of Revan Siddhappa versus Mallikarjun, 2010 Supreme Court, which is reported in 2011 volume of the Supreme Court cases. And therefore, there were two different views. One saying that word property, see, this all episode happened and 13 years long period is being consumed only to understand, only to implicate, only to interpret the word property. Whether property means separate property or property means ancestral property. Up to 2010, the Honorable Supreme Court was saying it is separate property only. However, in case of Revan Siddhappa versus Mallikarjun, the Honorable Supreme Court said, two honorable judges said, no, this is ancestral property also. This is beneficial interpretation rule, because it has been said by Justice Maxwell in his book called as Interpretation of Statute. He says, when the mind and the hand of the legislator are not working together, then there is interpretation required. And whenever interpretation is required, then beneficial interpretation rule is to be seen. Why the amendment? To confer benefit on illegitimate children. Then give maximum benefit. Why the Parliament is silent? Had the Parliament had intention to make it separate property, Parliament should have said only in separate property of the father. Parliament has said nothing. Parliament is silent as to whether it is ancestral or separate property. And accordingly, two judges said it is ancestral property. And look, therefore, there were two inconsistent judgments of the Supreme Court. One saying illegitimate child, son and daughter are entitled only separate property. Other in this case, Revan Siddhappa's case, we are saying no, it is ancestral property also. So these two views were referred to the larger bench in the year 2010-11. And since then, for last about 12 years, this issue was pending before Honorable Supreme Court, whether illegitimate son or daughter is entitled to claim only the separate property of father or also the ancestral property of father. And presently, this issue is referred to the larger bench of 3 judges. And that larger bench is deciding the case. Maybe, fortunately for you, before your examination, this issue may be decided by the Honorable Supreme Court. And therefore, friends, be aware, you must be absolutely aware of this present case on the point. This is the aspect in respect of the present pending case. Now, there is one more issue. Illegitimacy, as I have said in the beginning, may be out of void marriage or voidable marriage, or that may be out of extramarital relationship. If there is a relationship out of extramarital relationship, then section 16.3 has no application. Section 16.3, section 16.1, section 16.2, and section 16.3 of the amended Hindu Marriage Act of 1955 applies only in respect of void or voidable marriage. So it is out of marriage only, maybe void or voidable. However, if there is the extramarital relationship, no valid marriage, no voidable marriage, or there is no marriage at all, irrespective of that, there is extramarital relationship, and out of extramarital relationship, there is a child begotten. Whether that child is covered under section 16.3, whether that issue is pending before the Supreme Court, no. That issue is not pending before the Honorable Supreme Court. Issue is pending in respect of void and voidable marriages. And therefore, we have to also explain in respect of extramarital relationship. In case of extramarital relationship, without such marriage, issue is taking place, like a concubine or etc., then such a child certainly will not have any interest in respect of ancestral property. And therefore, such illegitimate child will have a right restricted maybe against father for maintenance and incidental rights. However, friends, there is a different law, and that is in respect of such a right of the child against mother. All this we have discussed against father. And if such a child has to claim such a right against mother, then you will find provisions are to be found in section 14, 15, and section 16 of the law. And what happens as per section 14, 15, and section 16? Section 14, section 15, and section 16 provides for. Section 14, yesterday we discussed. Section 14.1 says, property of a female becomes her absolute property. Section 15 and section 16 provides for the method in respect of the shares devolving on heirs of the Hindu female. And therefore, in respect of Hindu female, such a child born may be illegitimate child born, but should have full right against the mother. Because in respect of mother, there is no such classification as to ancestral and separate property. And therefore, this is the consequence when this judgment will come within short time, may be delivered by the Chief Justice of the Honorable Supreme Court of India as to void and voidable marriages, as to whether it is separate or ancestral property. And secondly, in respect of illegitimate child born without such marital relationship, are such different issues to be discussed. Friend, at the outset, I will say, what is the likely consequence? We shall not postulate, but here we have to see why marriage amendment of 1976. And consequence was to confer benefit on illegitimate children, maybe out of void and voidable marriages. And therefore, certainly, if we read Maxwell's book on interpretation, and in this connection, the J.P. Singh's book on interpretation of statute, certainly one will come to conclusion, or rather, we are of the opinion that property shall include ancestral property also. And therefore, that is the likely consequence from your examination point of view. Friends, second issue comes for our discussion today. Again, there is a much hotter discussion in the Supreme Court of India. And that was in respect of the case arising out of the application of Hindu Succession Act of 1956 to the daughter belonging to scheduled tribe. As we have discussed yesterday, the amendment of 2005, which came into force from 9/9/2005 and has conferred rights on Hindu daughter. She has been made co-partner and she is entitled to right in the father's family by birth itself. As soon as she is born, as per section 6, she is treated at par with the son, as per subclause A of subclause 1 of section 6, which says as if a son, or that is like a son. And therefore, she is treated as a son. Such a daughter in scheduled tribe, she instituted a suit against her father, brother, etc. And ultimately, it had been to the Honorable Supreme Court. Issue was before the Supreme Court whether a daughter or a woman belonging to scheduled tribe is entitled to take the benefit of this amended act or not. And you'll find surprisingly, very surprising facts came before, an application law came before all the legal fraternity in India. Most of the people may not be knowing this, but there is a provision incorporated in section 2, subsection 2 of this act. In section 2, subsection 2 of this act, it is stated that this act, which act? The Hindu Succession Act of 1956, which came into force from 17 June 1956, shall not be applicable. This act shall not apply to the members of the scheduled tribe, as provided in Article 366 into bracket 25 of the Constitution of India, unless there is a notification issued to that effect by the central government. So friends, there are three aspects to be seen. First, the Constitution of India in Article 366 subclause 25 thereof provides complete protection of scheduled tribes. Secondly, if this law is to be made applicable to them, can be made. It could have been made so applicable. But for that purpose, what is necessary? What is the condition precedent? That a notification to that effect must have been issued by the central government. Now issue arose before the Supreme Court of India, whether in such a case that shall be applicable or not. An issue was in the case of, I will state the name, Kamala Neti versus Special Land Acquisition Officer. Kamala Neti, N-E-T-I, versus Special Land Acquisition Officer. And case has been decided by the Honorable Supreme Court on 9th December 2022. Very recently, this case has been decided. 9th December 2022. Issue was before the Supreme Court of India and Lordship Justice M.R. Shah of the Supreme Court of India. Very interesting issue. Whether a daughter is entitled to benefit of this law or not. And the Honorable Supreme Court said that we regret. We cannot legislate. We cannot make the law because it is found that this Hindu Succession Act, which confers benefits on daughters for the first time after thousands of years by birth, this right it stands denied to the daughters belonging to scheduled tribes. Scheduled tribes, to take the benefit of this act, there must have been a notification issued by the central government. And it is found in the Supreme Court that there is no such notification till today issued by the central government. And therefore, this act is not applicable to scheduled tribes and the daughters. Very fact that Section 6, amended Section 6, which came into force from 9/9/2005, is a beneficial legislation. And therefore, it should have been made applicable to, by the central government, to the daughters also. By birth, they should take the benefit. However, the hands of the judges, honorable judges, were bound by this strict provision in the law. This particular section, Section 2.2, proved to be an hurdle for and to the scheduled tribe daughters or the woman to take benefit of the act. And the honorable judges, they said that we cannot make the law. It is Parliament's duty. It is the government's duty. Parliament can make the law. They have made the law. Now it is for the central government to legislate. And then only after notification, this legislation would be applicable to scheduled tribes. We cannot do that. And therefore, her right to claim such interest in father's family by birth came to be denied. Question will arise in our mind that this is the Honorable Supreme Court, and under Article 141 and Article 142 of the Constitution, they have got ample powers. Any provision of law which is contrary to fundamental rights can be declared to be void by the Honorable Supreme Court. Issue therefore is, if there is such a law which discriminates between, say for instance, Adivasi or scheduled tribe girl, daughter, and other daughters, then is not that violation of right to equality? There are two kinds of daughters. One belongs to other categories and one belongs to scheduled tribe. If one is given right, other is not given right, and therefore there is right to equality is violated. If right to equality is violated, then this law will become unconstitutional. Ultra, where is the constitution? It was within the hands of the Honorable Supreme Court to declare so, but they have not done so. Why? If you and me can understand, those learned people sitting in the Supreme Court, why they have not declared it so? Only for the reason that they cannot do it partially. Because for application of this law, the constitutional mandate is there. And that constitutional mandate is so as to protect the interest of the members of the scheduled tribe. Why at all? Why at all there is such a provision made in Article 366 subclause 25 of the Constitution? It is a protective discrimination. There is a discrimination, but that is protective discrimination. So as to confer such a discrimination or so as to protect them, there is a special provision made. Now, if this provision is declared to be unconstitutional, then that may be beneficial for daughter for this one act, but for other purposes, that protection might have been lost. And friends, therefore, this provision is not declared to be unconstitutional. Otherwise, it was within the competence of the Supreme Court of India to declare this section 2.2 to be unconstitutional. And all daughters should have been treated at par and equally. However, because of that constitutional protection, for all reasons, only for one purpose, that cannot be declared to be unconstitutional. And till the parliament, till the central government is issuing such a notification, law will not be applicable to daughters, Hindu daughters, and Section 6 benefit cannot be given, even though that happens to be beneficial legislation. And accordingly, the Honorable Judges said that the daughter will not be entitled to the benefit because of this technical reason in this behalf. Presently, you'll find, so as to make aware the central government, Member of Parliament, Mr. Wilson from the South India, he has written a letter and made a petition to the central government. Now, Parliament has done its job. Now the court has done its job. Now who is at fault? Who is to take benefit, to take the initiative? Is the central government. And so as to make central government to put in action mode, now Mr. Wilson, the Member of Parliament, he has written and made a petition to the central government. Let us see, friends, whether this comes to be true within short time or not. This is the consequence in respect of this discussion as to scheduled tribes and application of this law. Based on this, we go to the next consequence, friends. And the next consequence is application of this law. Very frequently, questions are asked on this. And when there was a seminar arranged by Bar Council of India and Bharati Vidyapit at Pune, there was some discussion as to this issue, I rightly remember. And issue is in respect of if a Hindu, say from Pune, he goes to London, he settles at London and he buys house or say office or something there, and then he dies at London. Which law is applicable is the question put. Or that was canvassed there amongst the aspirants or the candidates for the examination. Friends, there is a general version. A Hindu carries his own law with him wherever he goes in the world. But it means a Hindu carries his own law with him wherever he goes in the world. Like that, when you travel to London or say United States, you have to carry your passport and a visa. And it is said, this means along with passport and visa, you are putting in your bag or in your pocket, even the book on Hindu Succession Act. Your law, Hindu law, you are carrying with you wherever you go. But the issue arises now, on the backdrop of all these facts, whether Hindu law one of the query raised is, sir, please tell us by which law ST daughter is entitled to. ST daughter is not entitled to such benefit. The question raised is being answered that scheduled tribe daughter is not entitled to the benefit of 2005 amendment. This amendment will be beneficial to her irrespective of that. She can claim only when central government issues notification. Till then, no rights. So we are coming to this section 1 and its application. If a Hindu goes and settles in London and he has property in London and he dies at London, whether Hindu law will be applicable or not, Hindu Succession Act will be applicable or not. And for this purpose, we have to look into the provisions. And so as to understand the provision, answer is not only to be found in Indian law. Answer is not to be found in this Hindu Succession Act. Because if you read section 1, if you have got your book ready with you, the book on Hindu Succession Act with you just now, you just go into first section, first sentence. And it is said that within the territory of India. So this act is applicable within the territory of India. Hindu Succession Act has no extraterritorial application. Beyond the limits of India, this act has no application. This issue was discussed in the parliament when this law was being made. When in the year 1956, this law was being discussed in the parliament, this issue was discussed. Why not to apply this Hindu law to Hindu wherever he goes? If a person goes to, say, United States or to London, he shall be governed by Hindu Succession Act. That was the discussion going on. And therefore, extraterritorial, that is, application of Hindu Succession Act beyond the territory of India was in discussion before the both houses of the parliament. However, then it was discussed that, look, it is not only Hindu law. There are various international conventions. There are various international treaties and protocols. By virtue of such international documents, there is a provision made that each country shall have liberty of making its own laws as to disposal of property. And this disposal of property includes disposal by inter vivos, that is between two living persons, or by testamentary succession, or by intestate succession. And therefore, they are regulated by their own rules. Those principles are based on few more principles. One of the principle is known as lex situs. Other principle is known as lex, L-E-X, domicili. Lex situs means the place where property is situated. International law in this regard regulates this principle that lex situs means law of the land, the law of the place where property is situated. And secondly, the lex domicili, the domicile of the person, owner at the time of his death. So the place of the property, and secondly, his domicile is important. And therefore, answer to this question is to be found in section 5 of the Indian Succession Act 1925. For this purpose, three matters are connected. To answer such questions in examination, you have to take into consideration what is the effect of international treaties, then section 1 of the Hindu Succession Act, and thirdly, the issue with reference to section 5 of the Indian Succession Act 1925. And accordingly, you have to decide whether as per the Hindu Succession Act or as per the law there existing in London or in United Kingdom, this issue is to be resolved. And therefore, this is a combination of Hindu Succession Act, the Indian Succession Act, and the English law on the point. This is because of international treaties, international conventions, and protocols. Based on this, we go to the next consequence, friends, that is in respect of section 4. Yesterday, we discussed this to some extent. It was just elementary passing remarks. If examiner says that for the purposes of following things, the old Hindu law, ancient Hindu law is applicable even after coming into force the Hindu Succession Act of 1956. Which are those matters which are regulated? Which are those matters which are regulated by the law? Those matters which are regulated by the law which are not provided in Hindu Succession Act. Which are those matters? And you'll find one of such matter is partition. Partition, if you read the Hindu Succession Act from section 1 to section 30, then nowhere question of partition has been discussed. What is partition? Who can claim partition, etc. is not provided in the Hindu Succession Act or neither of the statutory laws. All those laws made by the parliament, there is no mention of partition taking place. Then where to find partition? Who can claim partition? How it can be claimed? Where to find? And this has been answered, especially with reference to section 4(1)(a) of this Act. Section 4(1)(a), as yesterday we discussed, relates to section 4(1)(a) relates to any text, any rule, any interpretation, or any usage or any custom of Hindu law existing immediately before commencement of this Act, means before 17th June 1956, shall cease to exist. That shall not be applicable. That is no more a good law if there is a provision made in this Act. If there is a specific provision made in this Act, then earlier law ceases to exist. It is not said ceases to apply. It is not said that it will not apply. It is said it ceases to exist. It becomes inoperative. As it becomes inoperative, it is not in existence for legal purposes and the new law to be applied. But if there is no provision made, specific provision made in this Act, then old law, scriptural law, in Veda's law or in Smriti's law will be applicable even today. And you will find accordingly, partition is such important aspect which is applicable in the courts today. We are governed and regulated by such principles. One of very interesting illustration I will give to you. That case was decided 140 years back by the Bombay High Court, by the Privy Council at Mumbai. And the issue was very simple, whether if there is grandfather, if there is father, and if there is a son, father, and grandfather, they are all living together. And father is living with his own brothers. So there is a joint family, grandfather and his brothers, then father and his son. This entire family is constituting a co-parcenary. And this grandson, he intended to file a suit against his father and grandfather for partition. Whether a son can file a suit for partition against father and grandfather during their lifetime or not, was the question before the Privy Council at Mumbai then. That was the case of Appaji. In case of Appaji's case, there were 4 judges who constituted the bench then of the Privy Council 140 years back. And this is a good law today also, Appaji's case. So there were 4 judges. Chief Justice Sargent was the English judge. Then there were 2 other judges of the Privy Council, and 4th judge was Indian judge, Justice Telang of Privy Council. And then when this case was decided by the court, all of them, they said that in this case, such a grandson cannot institute such a suit. He is not entitled to file such a suit. Only Justice Telang, he was dissenting. And today's law also, after so many years, this judgment of the Privy Council at Bombay has not been overruled. That stood the test of the time for more than 100 years. Why? Because there was discussed therein that accepting Bombay province, that is called as Vyavahara Mayukha sub-school. This Vyavahara Mayukha sub-school of Hindus, that is different than other schools. And therefore, even after coming into force the provisions of the Hindu Succession Act of 1956, you ask a simple query, who can institute a suit? Where to find? In Succession Act? No. Answer to this query is not given in Hindu Succession Act. It is not given in any of the laws of the Parliament of India. It is to be found in Vyavahara Mayukha, applicable to Bombay sub-school 150 years back. And therefore, it has been opined that a grandson cannot file a suit against father and grandfather when they are living together and collaterals are living together. However, if you go to, say, other schools, say, at Uttar Pradesh or say at Madhya Pradesh, then they have got their different schools. Excepting Bombay, excepting Vyavahara Mayukha sub-school of Bombay or Mumbai, elsewhere, even a grandson can file a suit against father and grandfather, and there is no need of anybody's consent. Why such difference? Law in Mumbai province is different and law in other provinces is different because of the earlier law. That is by virtue of section 4(1)(a) of the Hindu Succession Act. Friends, based on this, we have to go to the next consequence. Very recently, we have discussed that yesterday we have discussed that in the year 2005, the Parliament of India, based on 174th report of the Law Commission of India, has done what? Based on that, they have enacted an amendment. the Hindu Succession into bracket Amendment bracket Complete Act 2005. Then issue arose that first there was in Maharashtra, what was the position? Earlier, before 56, there was 1937 legislation. Then in the year 1956, the Hindu Succession Act. And then what happened thereafter? In Maharashtra, on 22nd June 1994, there was a state amendment whereby daughter was made a co-partner, unmarried daughter was made a co-partner. And on 992005, now there was the, again, central act or the central amendment, which shall prevail. Issue of these various laws, which shall prevail, was the question before the Supreme Court, before the Honorable Bombay High Court in its Aurangabad bench. Before the Aurangabad bench, issue arose whether there is inconsistency between them. Now, this Parliament's law enacted in the year 2005, which became applicable from 992005, nowhere says, it is nowhere stated that we hereby repeal the state laws. So there are state laws, there is central legislation. Then issue is, if this central legislation has repealed the state law, matter is all right. This law will come to an end, but that has not been done. By the central legislation of 2005, these state laws of 1986 Andhra Pradesh, 1990 Tamil Nadu, 1994 state of Karnataka, and 22nd June 1994 state of Maharashtra. There were 4 laws, and now here is a Parliament's law again. First 56 Parliament's law, then 4 states law, and again Parliament's law. Issue is, if this law is not repealed, 4 laws are not repealed by this recent 2005 amendment of the Parliament, then whether both are existing was the question before Aurangabad bench of Bombay High Court. And issue was referred to Justice Kankanwadi Madam of Bombay High Court at Aurangabad bench. Very recently, this case has been decided. And when this case was decided, this case is decided in the last year itself, in the year 2022. That was the case of Babu Jyotiram Jadhav and others versus Muktabai Vaman Rao Somavanshi, reported in 2022, volume number 1, Bombay CR 294. I'll repeat the case number, case name, Babu Jyotiram Jadhav and others versus Muktabai Vaman Rao Somavanshi and others, wherein issue was before leadership was as to how to relate, how to correlate first 56 legislation, 4 state laws, and then again 2005 amending act. If there is such a consequence, then issue arises of these 3, whether subsequent Parliament's law automatically will repeal the state laws or not, was the question. And if you are faced with such a very recent judgment of the Bombay High Court, Aurangabad bench, you must be aware. Couple of months before this judgment has been delivered. And in this case, Honorable Leadership has explained this very succinctly, very nicely. And it has been observed that succession is in a concurrent list. Succession issue is in the concurrent list or the 3rd list in the Constitution of India in 7th schedule. It is list 3, 7th schedule. And it is regulated by Article 254 of the Constitution. Article 254 of the Constitution regulates this. So what you have to consider at this juncture, if at all question is asked to you, either in written or oral examination, then mind well, first, succession is in a concurrent list, that is 3rd list in the schedule to the Constitution. And secondly, Article 254 regulates this. This entire episode, this entire interrelationship amongst these 3 provisions have been explained. It has been explained by the Bombay High Court. And it has been held that if it is Article 254, 1 and 2 is to be discussed, then if it is the law made by the state with the consent of the President, then it will prevail over the central law. Try to understand. There was 1956 law. Irrespective of existence of 1956 legislation, the state of Maharashtra in the year 1994 made the state law. Why state law prevailed? In Maharashtra, state law prevailed in the year 1994, whereby unmarried daughters were made co-partners, while as per the original law, they were not. then why the state law of 1994 was prevalent and that prevailed over the central's law? Because when 1994 amendment was effected, as per Article 254, assent of the President of India was obtained for such amendment. When the consent of the President of India is obtained for such an amendment, and therefore that amendment prevailed. Now issue is that central legislation 1994 amendment, this prevailed over the Parliament's law. Now again Parliament made the law. This Parliament's new law of 2005, whether will prevail over the amendment or not, state amendment or not, and has been explained by the Honorable Bombay High Court in this case, in Jyoti Ram's case, and has been held. This is called in constitutional jurisprudence as the occupied field theory. The field area, field means area, is already occupied, hence called as the occupied field theory. If this subject of succession is already occupied, means there is already legislation being made, law has been made by the state legislature, and now Parliament intends to make law on the same issue, whether there is express repeal is necessary, and has been observed in this case by the ladyship that no, there is no need. If the Parliament passes a law and again President consents for the same, then state law will be automatically repealed. Are you getting the thing correctly? Because there is no need for express repeal of the state law. State laws, for state amendments, they are automatically repealed if this central law again gets the presidential assent. This is the consequence in respect of these twofold relationship in respect of the state and central legislation. Then comes the consequence. Yesterday we discussed. Briefly, I will make mention thereof. As per Section 6, the provision is made, if you read it properly, that any alienation, disposition, or any partition before 20th December 2004, that is to be saved. Therefore, even though daughter is given such a right and the benefit, but such right or benefit may not be available to her if already before 20th December 2004, any alienation means transfer, disposition, transfer, or any partition is effected before 20th December 2004, then that shall be saved. That shall not be questioned. Why? Why this date comes, friends? Have you ever thought over this? Why this date came as to 20th December 2005? Why not? The transactions entered into before that date are to be considered. And after that date are to be considered. And it is said that any transaction entered into, any transaction of alienation, etc., entered into thereafter is not to be considered, is not to be taken into consideration. That is not valid. And if anything entered into before, then that is valid. So transactions, the cutting off date for validating such transaction was 20th December 2004. And friend, this date, if at all, examiner requests and requires you to answer this query, then it is to be understood that this is the date when this bill was moved in Rajya Sabha, that is one house of the parliament, first time. And therefore, as the bill was moved in the houses of the parliament, to all the Hindus in India, they become aware that this law is coming. Constitutional discussions will take place. The parliamentary discussions will take place for longer time. And meanwhile, all such transactions will be effected. Whereby, by these bogus SAM transactions, intentional transactions, daughters would have been defeated or their rights would have been defeated. And hence, the parliament has put this deadline. All transactions are done after bill has been moved in Rajya Sabha. They are not to be treated as valid transactions. However, all transactions entered before that are to be valid transaction and they cannot be questioned. Issue arises. Issue arises in this behalf that what transactions? What transactions? And it has been said transactions are threefold: alienations, dispositions, and partitions. These three kinds of transactions are either protected before this and not protected after this. Issue arises as to partition. You'll find there is an explanation below subclause 5 of section 6. section 6, 1, 2, 3, 4, and 5. Below that, there is an explanation. What is partition? The word partition as used by the Parliament in section 6 means what? And has been explained by the Supreme Court that the term partition, that explanation provides that partition means and includes partition which has been registered under the provisions of Indian Registration Act of 1908 or by decree of the court. Therefore, partition to be valid should be only by two methods. Which two methods? First, it should be registered, not only executed, but registered in the registrar's office under that Act of 1908. And secondly, it shall be by decree of the court. If there is oral partition, then if there is oral partition, then you will find that under these provisions of section 6, subclauses 5, and then the explanation below section 5, this will not relate to oral partition. Oral partition stands excluded. And if there is a suit based on oral partition, what will happen? And has been discussed and stated by the Supreme Court of India in the case of Vinita Sharma versus Rakesh Sharma. Yesterday we discussed. Judgment has been delivered by the Supreme Court on 11th August 2020. When this judgment was delivered on 11th August 2020 by the Honorable Supreme Court by 3 judges bench of the Supreme Court, they have explained this oral partition theory. And that is very important. The version of the Supreme Court, what Supreme Court has observed, is not befitting in the statutory provisions. The law says, the provisions in section 6 and explanation says partition means registered partition and partition by decree of the court only, means no oral partition. Now issue was before the Supreme Court, what shall happen to oral partitions? All this was the consequence of 174th report of the Law Commission of India. In the meanwhile, in the year 2008, there was 208 report of the Law Commission of India. 208th report submitted by the Law Commission in the year 2008. And that report stated that under certain circumstances, even oral partition must be considered. So that was the recommendation by the Law Commission to the Parliament of India, to the Government of India. And now issue was before the Supreme Court whether in this case, this particular consequence in the form of oral partition will be applicable or not. And has been held by the Supreme Court in this case that under such circumstances, the oral partition is also valid, very likely to be asked by the examiner in examination, because this is something unusual. Usually it is said by the Parliament, by the Supreme Court, we never make the law. Supreme Court or any court will not make any law. We simply apply, interpret law and decide the cases. However, in this case, Supreme Court has said something which is not in the Act, which is beyond the Act. Therefore, today, if we read Supreme Court judgment and this Act and the explanation, then it is like this. Partition means registered partition. Partition means partition by decree of the court, and also oral partition. So oral partition, even though not in the law of the Parliament, is included in the list. And therefore, you'll find this oral partition theory has been advocated by the judges of the Supreme Court, but it is condition 1. This is not only oral partition. There are two kinds of observations made by honorable judges of the Supreme Court while deciding Vinita Sharma's case. And they have said that oral partition is a valid partition. Oral partition is valid partition even as per section 6 of the Act, that is Hindu Succession Act, so that daughter to get the benefit, the issue as to not only those two kinds of the partitions, but oral partition theory is also applicable. What is oral partition then? To be valid oral partition, it should be satisfying 3 conditions. Those 3 conditions the examiner may ask you. It says in Vinita Sharma's case, in the last concluding paragraph of the judgment, it is said that even oral partition can be relied upon, but it must be supported by long entries in the public document. These are the 3 requirements. What are the 3 requirements? that oral partition theory may be advocated and accepted by the court, but such oral partition shall be included in the revenue entries for long period and not stray entries for continuous period. And in the revenue record and public document, this shall be reflected. Then only oral partition can be accepted. Otherwise, oral partition cannot be accepted. It is further said, if there is oral partition advocated or pleaded, and there is only oral evidence is given, then that should be outrightly rejected by the court. So try to understand, oral partition theory means either it should be oral partition, and this oral partition, it must be supported by entries in the public record. There shall be continuous entries in the public record, and there shall be no stray entries. So oral partition shall be supported evidence, and evidence shall come from independent public document. If you say that there was an oral partition and oral evidence is given, then such oral evidence and such oral partition theory shall be outrightly rejected by the court, is the observation and direction by the Honorable Supreme Court. This is with reference to oral partition theory in this behalf. Now issue comes, friends, as per section 15 of the Hindu Succession Act. In what manner the property of the Hindu female shall pass on after her death? It is said, if the property is inherited by her from her father, and there is no son and daughter, then such property shall go to heirs of father. If you read to section 14, 15, and 6 and 16, then you will find that in the event of death of the Hindu female, her property after her death will pass on to her son, daughter, and husband. Son, daughter, and husband, and also includes predeceased sons and predeceased daughters, son and daughter, etc. So first category A is son, daughter, and husband. If they are not present, then heirs of husband. Then heirs of husband. And if they are not present, then there is a consequence in respect of the father and mother. Then if there are no father and mother, heirs of father, and then heirs of mother. Therefore, there are such consequences. It is stated, if property is inherited from father's side, it shall go to father's or father's heirs. Issue therefore is how to reconcile between section 15.1 and section 15.2 of this act. Section 15.1 and section 15.2 says, if there are no issues but only husband and there are no son and daughter, or son and daughter, then property will not go to husband, but that will go to heirs of father. Therefore, section 15.1 and section 15.2, they are diametrically opposite. They are opposite to each other. Therefore, the word appears here, inherited from father. Therefore, if the property is inherited by the female from her father, then this consequence arises. Inherited. Inherited means by inheritance. Therefore, the word inheritance came to be interpreted by the court in this behalf. How this is to be interpreted? What the word inherited means. And if there is a father making his will, and father has made the gift to the daughter, and father dies, and then this female, she has gifted property, or she has received the property under will, and then she dies with this property. Law makes a difference. After father's death, property comes to her by inheritance, by succession, then section 15.1. And if property is not inherited by father, from father, but it has been gifted by the father, or the property has come to her by will, testamentary succession, then section 15.2 applies. Try to understand. I will explain in one sentence. There are two methods whereby father's property will go to his daughter. Father has either, he is dead and his property by succession passes to daughter. It is inherited. This is called as inheritance. It is intestate succession. This is one method. And second method is father has made a will, and by his will he has bequeathed the property to his daughter, or he has during his lifetime gifted the property to his daughter. And such two kinds of daughter, they do die. One daughter inherited the property. Other daughter, she got gift from the father. And now these two different daughters, they do die. There is a difference. If they have inherited the property, then the section 15(1) applies. And if the property is gifted or property has been received under the will, then section 15(2) applies. And then in that event, the heirs of the father will be entitled to coming back of the property in their hands. This is the consequence in respect of this and similar such illustration is provided in respect of this discussion in Mulla's Hindu book, Principles of Hindu Law by Jurist Mulla. And this explanation is stated as to be illustration 8 on page number 1196 of Mulla's book. Friend, this was with reference to the consequence as to concept. Then comes the next issue with reference to notional partition. Every now and then we discuss notional partition. Most of the judgments and arguments you may be hearing in the courts, they are based on notional partition. What is notional partition? Where it has been defined? And you will find surprisingly, the concept of notional partition is not defined at all in any law so far. It is not in statutory law. Nowhere the word notional partition has been used. This is the phrase. This is the terminology used by the advocates and judges while deciding the cases and arguing the cases. And this comes from section 6. Section 6 provided in this behalf. What old section 6 yesterday we had discussed, that when a male Hindu dies after commencement of this act, having at the time of his death his interest in the mitakshara co-parsonery, then the same shall pass on to his co-parsons by survivorship and not as per this act. However, provided that if he is survived by any female heir of class 1 or any male heir claiming through female heir of class 1, then this shall pass as per this act. And it is further said by explanation below section 6. An explanation below section 6 says his interest, which is to pass, his interest in the property is his share in the property immediately before his death. So 1 minute or 1 second before his death, what was his share in the property? It should be his share in the property. And therefore, it should have been separated, as if separated. In fact, not separated. There is no by meets and bound division. Nevertheless, his share is determined and defined. Determining and defining the share without actual partition by meets and bounds is a notional partition. It is a technical partition, but not factual partition. Factual partition means when the shares are defined and there is division by meets and bounds. For partition to take place, two things are necessary. And such two things are, firstly, share is to be defined. What is the extent? 1/4, 1/5, etc. And secondly, this should be separated by meets and bounds, separate possession. So, community of ownership result into separation of ownership and possession. This is partition. But in respect of notional partition, there is no such actual partition taking place. Now, section 6 has been substituted by new section 6. What happens in new section 6 or amended section 6? If you read properly, amended section 6, then you'll find in section 6, subclause 3 thereof. Read properly, section 6, subclause 3 thereof. And it is said, when a Hindu dies after commencement of this act. Then it is said in subclause 3 of section 6 amended, it says that then, in that case, the property shall pass to his heirs, not by survivorship, but as per this act. And there shall be a partition deemed. There is a deeming provision. Actual partition is not taking place. Just now, a Hindu has been dead and gone. Immediately, at that second only, at that point of time only, it is said that his share has passed on to his heirs. Their shares have been defined as per this act and not by survivorship. This is said to be a notional partition or concept of a notional partition when shares are defined, but no actual partition by meets and bound taking place. Then comes the next consequence, friends. That issue is discussed with reference to section 30 of this law. How to read this? Where is the potential for this? If a question is asked that up to 2005 or after passing of the 1956 law, that is 17 June 1956, whether a female could make and could give her property by will or not, her share in the property or not. And it is said, if there was a share there was a co-parcenary, then she had no share and she could not make a will in respect of co-parcenary property, because there was no vesting right. For the first time, such a right has been created by 2005 amendment by amending section 30. Please go to section 30 and you will find the words substituted or inserted by 2005 amendment. By 2005 amendment, what has been done is, by inserting such amendment, what has been done is that now male as well as female can make the will in respect of her share in the property. So such an amendment has taken place with reference to 2005 amendment in respect of Hindu male as well as female. Male was given right. Section 30 was providing such a right in respect of a male. In respect of his right in the co-parcenary property, he was entitled to make a will as per section 30. Testamentary succession was permitted. However, now, by virtue of amendment in section 30, now there is a provision made for disposal of such property by will even by a female. Why? Why such amendment was necessary? Amendment was necessary because by 2005 amendment, daughter is made a co-partner and therefore she is like a son. And therefore, if son can make a will, why not the daughter? And therefore, there was a need to amend section 29 also and section 30 also. And therefore, male as well as female can dispose of the property by their will. Then comes the next consequence in respect of converts. If there is a family, co-parcenary, etc., and one of them, he has converted himself. Is he entitled to any share or not? He has given up Hindu faith and he has joined some other faith. Whether he is entitled to his share in the property or not. And especially you'll find section 27 provides for the consequence. And it is stated here carefully, descendants of the convert are disqualified. If you read properly, convert is not disqualified. That person who has given up Hindu faith, Hindu religion, is not disqualified. Even though he goes to some other religion, yet he can claim the share in the father's property. He is not disqualified. His heirs are disqualified after his conversion. Therefore, if the person has given up Hindu faith and he has joined some other faith, and then further children are born to him, those children, descendants, they are disqualified. This gentleman is not disqualified. This is the consequence in respect of this category of persons. And similar issue as before the High Court, whether such person shall be entitled to such benefit or not. Issue was before Andhra Pradesh High Court in case of Shabana Khan versus D.B. Sulochana. I'll repeat, Shabana Khan versus D.B. Sulochana, 2008, volume number 2, HLR, page number 111, Andhra Pradesh High Court, wherein the Andhra Pradesh High Court has held that convert is not disqualified. Even though person has given up his faith, he is not disqualified. But after his conversion, any children are born to him, then they are disqualified. There is a further lever provided. Very interesting. If there is a father and there is a son, and this son has given up the Hindu religion, he joins some other religion, and then some children are begotten, then this convert is not disqualified. Children are disqualified. If father dies, original father dies or grandfather dies, then son will get, but the grandsons will not take. And now they have realized this son and grandson, they have again came into Hindu religion. And when they join again Hindu faith, and then grandfather died, then section protects them, and it is provided in section 26 that such persons are protected, and under such circumstances, they will not be disqualified. Means in short, at the time of death of the father or grandfather, whether such persons were enjoying Hindu faith or not, Conversion has little consequence. They should have been in other faith, in other religion at the time of the death, from whom property is to come to them. If before death they again coming to Hindu religion, then they are not disqualified, is the simple consequence thereof. Yesterday we discussed with reference to section 14. Yesterday we discussed section 14. What was section 14? Property possessed by Hindu female, whether acquired before or after commencement of this act, shall be held by her as absolute property and not as a limited property. So, what is the consequence? Section 14.1. Section 14.1 makes such interest in her hand, such property in her hand as absolute property. Therefore, property should be possessed by her before or after commencement of this act. Then, if such property is possessed by her, then that shall become absolute property. However, examiner may not ask you this question. That is provided in section 14.1. Section 14.1, bottom line consequence is property which is not absolute but is possessed by her will automatically become absolute if she is possessing it on 17 June 1956. Automatically she will be absolute owner thereof by virtue of section 14.1. However, section 14.2 is different. Section 14.2 says, however, property is by way of gift or will to that female woman, wherein there are restrictions imposed while giving by will or other disposition or by will or gift, and there are restrictions mentioned. Then the female will get the property with those restrictions. She will get the property with those restrictions and she will not get the absolute interest in the property. This is the consequence stated with reference to section 14.2. Friends, try to understand. Section 14.1 is different. That makes her absolute owner. While section 14.2 is different and that makes and continues to be limited property or restricted tenure of the property in the hands of Hindu woman or Hindu female. Then comes the next consequence to be stated. Issue was very simple. When this act came into operation on 17 June 1956, 17 June 1956, the issue was whether this act is prospective or retrospective. Prospective means applicable thereafter. Retrospective means applicable before 56, 17 June 56. Issue was therefore, this entire act is applicable in the event of a death of a Hindu. Then this act applies. Then succession becomes applicable. Issue therefore is, if death occurs of a Hindu before 17 June 1956, whether this act will be applicable or not. Are you getting me properly? Issue is very simple. There is a father and there is a co-parcel, etc. And father died before 17 June 1956. Issue of succession comes. Is this Hindu Succession Act applicable or not? And was the question before the Supreme Court of India and decided by the Supreme Court in the year 1966. The name of the case is Iramma, E-R-A-M-M-A, Iramma versus Virupama, V-E-E-R-U-P-A-N-A, Virupana, reported in AIR 1966, Supreme Court, page number 1879. In the year 1976, therefore, the Supreme Court of India held that this act has no retrospective application. This act has no retrospective application. It has no retroactive application also. This has only prospective application. And the last but the least for today's discussion, with reference to the provisions in the Special Marriage Act. If you have understood the consequence, or this must have been canvassed by the other dignitaries or the speakers while their discourses. Issue is very simple. There is Special Marriage Act of 1954. And there is a provision made in section 21 of the Special Marriage Act. Section 21 of the Special Marriage Act as it stood before amendment. Today there is section 21A also. But as per section 21 of the Special Marriage Act, if there is a marriage solemnized under Special Marriage Act, then this act has no application. Succession of such person, succession of a Hindu who married under Special Marriage Act, and his marriage has been registered under Special Marriage Act, and then he dies. the provisions in Hindu Succession Act were not applicable to him. And he was regulated by the provisions in the Indian Succession Act of 1925. Therefore, the Indian Succession Act of 1925 was made applicable in those cases when person married under Special Marriage Act by virtue of Section 21. This was injustice. And therefore, this act came to be suitably amended and Section 21A has been inserted. Please get it correctly. Section 21A. Section 21A is amended section. And by virtue of Section 21A, what has happened is now there are two kinds of marriages. And such two kinds of marriages, they are a Hindu is marrying to another Hindu and registering under Special Marriage Act. A Hindu marrying to another Hindu and registering under the Special Marriage Act. And a Hindu is marrying to non-Hindu under Special Marriage Act are the two categories under Section 21A. And therefore, if it is a marriage between two Hindus, if it is a marriage between two Hindus under the Special Marriage Act registered, then they will be regulated by the Hindu Succession Act. And the Indian Succession Act will not be applicable to them. This is amendment in Section 21A. And if there is a marriage between one Hindu and other spouse is non-Hindu, then in that event, even after amendment, the death of either of them will be regulated by Indian Succession Act. Succession will be taking place under Indian Succession Act, not as per Hindu law. This is the consequence, friends, in respect of Section 21 and Section 21A of the Special Marriage Act, application of the Hindu Succession Act and the Indian Succession Act. Friends, with this, we come to an end as to how to read this book, how these various provisions are to be understood in the light of the examination, coming examination. With this, friends, I conclude and I really thank the organizers, the office bearers of the Bar Council of Maharashtra and Goa for giving me this platform to have, friends, dialogue with you. And with this, I take this opportunity to extend to you my all best wishes for your career as a judge of the family court. And with this, I conclude. Thank you. Thank you very much.
On behalf of Bar Council of Maharashtra and Goa, I would like to extend my heartfelt thanks towards our today's chief guest, Honorable Advocate Dr. Sudhakar Avhad, sir. Sir has explained various aspects of Hindu Succession Act with various judgment, which will definitely help of all our participants from the exam point of view. I would like to extend my gratitude towards Chairman, Vice Chairman, and all the esteemed members of Bar Council of Maharashtra and Goa. I would like to extend my special thanks towards our Vice Chairman of Bar Council of Maharashtra and Goa, Dr. Uday Varunzikar, sir, who is also coordinator of this lecture series. Thank you very much, sir, for organizing this lecture series for all our participants. I would like to extend my gratitude towards all the participants who have participated in this lecture series. Thank you each and everyone. I now request Sharath, sir, to conclude this lecture series. Thank you, sir.
Thank you.
Yes.